G'day Year 11s. I want to just have a chat to you in this video about using cases to support our writing of essays and reports. The idea being is there's an expectation in legal studies that you've got to look at the facts of a case and take the facts of a case, the important elements of a case, and use them to help build your argument. Use them to provide, for example, use them to provide an example of what is not fair around a case, or to illustrate exactly how the law works in a situation. Particularly want to do it with legal studies, looking at our current syllabus. So I want to talk a little bit about that. But let's start with this question here, which says, what are you trying to do when you use a case? So the first thing I've put there is you're looking to illustrate the legal issue that you are considering. So if you're looking at a situation of defamation, and perhaps you're looking specifically at online defamation, you want to have a look at some legal cases around defamation, online defamation, that give you some information about how that works in practice. If you like, you're using a real-life example of the legal issue from the court system. You're taking your essay or your report from just being about theory to actually saying, well, here are some real-life cases from the court system. Because when we talk about cases, we're talking about things that have actually happened in the court system. We're lucky that there's a database of them and that we can go find cases and use them. And so we're trying to use the things that happen in the case as a way of building our argument. For example, perhaps our argument is that if we were looking at a topic like defamation, that the court system doesn't deal well with online defamation, with social media and defamation. So we might look at some cases where that's true. Perhaps we looked at some cases where there's some really, really big payouts from social media, tens of thousands of dollars. And so we'll question whether it's really worth it, because does social media have that bigger readership for some individual person compared to, for example, something in a newspaper or whatever? So we'd be looking for cases that illustrated that point. For this topic, we're looking at negligence. So we're interested in cases around negligence, and people have chosen specific areas that they're working on. A lot of you have chosen contributory negligence, when people get into the vehicle with someone who they know is under the influence of alcohol, a driver who's under the influence of alcohol. So it's going to be cases like that that are going to be interesting, where we're going to look at the facts and we're going to use what happened in the case to question, was the outcome fair and just, and how could recommendations have made it better? But let's look at the criteria. Now, this is from the syllabus. So that's the overarching document that says what we have to study. And we're particularly talking about a variety of criteria, but I particularly want to focus on the select criteria. Right. So this is usually the second criteria you see on your criteria sheet for a report or an essay. And you have to select legal information from sources. For example, cases. The first thing that they ask you to do. So that's part of the skill that we're doing here, is we're putting together a series of sources that almost always will include cases, not 100% of the time, but certainly it will be for this piece of assessment work, and as well as using legislation. So you want to be talking about the act that covers negligence in Queensland. You might look about other websites, government websites, reports, expert comments. I think is often a really good idea, particularly if experts have been talking about a need for change in the same area that you are looking at. So they're the sort of sources that we're looking at to use. If we go a little further into the comments here, they ask you to find a discerning choice of current and relevant legal information from primary and or secondary sources. So just from sources relevant to Australian or Queensland. In this case, it's a law reform topic that I've cut and pasted this from. Don't get too worried about that. But the first thing is a discerning choice of current and relevant legal information. So discerning means that you're not just using any old cases. So, for example, we know that one of the first important cases we looked at was the slug in the bottle case, but that's not going to be highly discerning or relevant to most of your research because you're looking at different, more specific topics. So we want to find cases that really help illustrate our topics. We have to use that information perceptively to build an argument. We don't just put all the facts of a case in, because otherwise that could take 1,000 words itself. We've looked at cases. You've all talked about how many paragraphs we have to look through. In that case, we looked through about negligence and superannuation earlier in the year. And we have to document, and this was another video that I put up around reference lists. We have to document this in terms of reference lists. So they're the things we're looking to do. Now, the cases fit into the other criteria as well, but I just thought this was a really key one to highlight. I want to now go and highlight this in a couple of possible situations. Right, the first thing is this argument here, the use of a case in this argument here. Now, in this case, the student is talking about vicarious liability, and that means that it's not always the person who's responsible for negligence that they sue. Sometimes they look to sue the employer, and that's an interesting legal part of negligence. And they're discussing this. Here's the case that they choose to illustrate some of the shortcomings of vicarious liability. And they're writing it from a stakeholder perspective. They're writing it from the perspective of the plaintiff, the person bringing them the complaint. They're saying this isn't working well. So here's where they start talking about the case. Here's where they start talking about the case. So this is in the relevant case of Prince Alfred College versus ADC. So ADC was the child involved, where the plaintiff was sexually abused by his housemaster, boarding housemaster. In the proceedings, the plaintiff decided not to pursue Bain, but rather to take civil action against the school. Prince Alfred College was not at fault. It was found vicarious liable for wrongdoing act of the employee. That said, though, when they looked at this idea of vicarious, so the idea is that an employer has some responsibility for the action of an employee. It was found, however, that due to the vicarious liability not covering legal omissions or deliberate negligence, so that's the deliberately negligent act of the teacher, the school's non-delegatable duty of care did not extend to the intentional criminal conduct of a teacher. So in this case, the school couldn't be sued for the sexual abuse by the housemaster. So in short, the school was not held liable for the actions of Bain, even though if it wasn't for the school's minimal background check of Bain, he would never come into contact with the plaintiff and hence would have not sexually assaulted him. So the facts of the case were that it was that sexual abuse. The author of this piece of writing is saying, well, if the school had properly performed checks, that they would have protected the plaintiff from the sexual abuse and shown by using the facts of this case that this application of vicarious liability seemed to be unfair, not just and equitable to the person bringing the claim. So an example of how the complaint was used in this case. I also want to move here just to the textbook and have a look at how a case is used here to illustrate a point. So in this case, the textbook at this stage is talking about the proportion of a proportioning responsibility in different accidents. So talking about contributory negligence, when more than one party is involved for responsibility. So here it says contributory negligence is most often seen in negligent cases involving motor vehicles. Often both the plaintiff and defendant can be at fault and there's an apportionment of liability between the plaintiff and defendant. They then go on to use a case to illustrate that. So they quote the case in the way that they should, the two parties, the date, the court. In that case, the evidence was that the plaintiff did not slow down after he saw the horse. So they're now taking the facts of the case to show how that illustrates this idea of contributory negligence. So the plaintiff didn't slow down. The court found that his failure to slow down was more than a mere error of judgment. The plaintiff should have seen there was an obvious danger, should have promptly decreased his speed considerably, what would have enabled him to pass the horse safely. That said, though, the greater proportion of responsibility for injury was to be borne by the unidentified driver who struck the horse, and found that, looking at the facts, there was an apportionment of liability of 80-20. So that they're using the case there, the facts of the case, to illustrate what happens there. Look, I hope looking at these couple of things gives you some idea for how you can use cases. In the handout I gave you, as we came to the end of this, there was that great case, the great article, I thought, around the extension of the murder ruling, and looking at the ship on in New South Wales, and whether allowing people off with COVID-19 without proper checks could lead to claims of murder, the ABC article. Have a look at that and how they've used cases as well, because it's a big part of how we work with legal studies, and one of the things that you need to be able to do with the different criteria.